Welcome, everyone. As we're waiting for people to join, please feel free to add your name, your title, and where you're joining us from today, and we'll get started momentarily. And again, feel free to introduce yourself in the chat. You can tell us your name, your title, where you're joining us from today. And to get this conversation started, Danny is going to launch an anonymous poll to tell us a little bit more about who's in the room. And we know that when lawyers think about engaging with the press, it can generate lots of different reactions. So please let us know about your experience engaging with the press and some of the emotions that you might be bringing to this conversation today. If you have lots of experience, little experience, the thought of it is exciting to you, stressful to you, we have a few different options on the screen. Thanks, Francisca, for getting us started with the introductions. I'll give folks a couple more moments to answer the poll before we start. All right, Danny, if you want to end the poll and show the results, that would be great. So it looks like we have a nice mix of folks joining us today in terms of your experience with the press. So we have some folks who have quite a bit of experience, others who don't have too much, and kind of a mix of emotional responses. So some people are stressed, some people are excited, and some people are a combination of feeling a little bit anxious and a little bit excited at the thought of engaging with the press regarding your legal cases. So thank you for indulging us and sharing that. So again, welcome everyone, and thank you so much for joining us for today's Legal Network for Gender Equity webinar, Ethical and Strategic Considerations for Working with the Media to Support Your Clients. I'm Lizzie Vogel, Senior Counsel at the Times of Legal Defense Fund and Legal Network for Gender Equity team here at the National Women's Law Center. I'm really thrilled that so many of you are joining us today to talk about this important topic. Before we dig in, I want to extend my sincere thanks to those of you who helped make today possible. Thank you to my colleagues at the Law Center, Danny Stewart and Jennifer Montino and Michael Godinez for your help with today's webinar. Thank you to our fantastic presenters who I will have the pleasure of introducing you to you shortly. And finally, thank you to those of you in the audience, our members of the Legal Network for Gender Equity. Thank you for being here today and for all the work that you do on behalf of survivors. And speaking of the legal network, I'm proud to say that all three of the presenters that you'll hear from today are members of our legal network. And some quick background on what that means for those of you who are here who might not already be members. The Legal Network for Gender Equity was launched in October 2017 and is housed at the National Women's Law Center. The network connects individuals experiencing sex discrimination, including sexual harassment, at work, at school, or in accessing healthcare with attorneys who are willing to take on these types of cases. The lawyers who participate in the network agree to provide a free initial consultation to individuals who contact them through the network, and in some instances can take on sexual harassment or other sex discrimination cases for free or for a reduced fee. If you are not part of the network, at the link that Danny is adding to the chat, you can learn more about the network and how to join. Please consider joining if you're not already a part of it, if you think it would be a good fit for the work that you do, or please share it with others who you think would be a good fit. We're always looking to expand the network and in turn, the number of survivors that we can assist. And before I move on to introductions, just a few quick housekeeping notes. This webinar is being recorded. We'll share the recording and the slides from today on our website within the next few weeks. As always, you can find these webinars and other resources on our website at the link that Danny is also about to add to the chat. And then just another note, we will have the chat function and the Q&A function available, but we do ask that you primarily hold your questions until the end, and we will have ample time then for audience questions. And now moving on to our panel for today. So I am so thrilled to introduce our panelists who bring such depth and breadth of experience to today's topic, which I know, as we got at a little bit in the poll, can be a bit thorny for us risk-averse attorneys. But today we're going to really take that topic head on, and we're really going to hear from true leaders in the field about how we can use the media to support our clients both ethically and strategically. So there are so many impressive things to say about our panelists, but I'm going to keep these introductions brief. There's a longer bio on the slides in front of you, and we also send it out by email. But let me just briefly introduce each of our speakers. So first, I'd like to introduce Robert Baldwin III. I'm particularly excited that Robert's joining us today because not only is he an employment attorney and part of the legal network, but in a former life, Robert was an associate producer at NPR. So having been on both sides as a journalist, as an attorney, Robert really brings a unique perspective to today's conversation. Next, I'd like to introduce Subodh Chandra. Subodh is currently managing partner at the firm he founded, but came to this position after serving as a federal prosecutor and the law director for the city of Cleveland. Subodh has deep experience working with the press during his representation of high-profile clients and cases, and also has extensive experience teaching and training attorneys on this topic. And finally, I'd like to introduce Debra Katz. Debra is a founding partner of her firm, and as the Washington Post reminds us, the quote, feared attorney of the hashtag #MeToo movement, having represented many high-profile clients, including Christine Blasey Ford and survivors who were sexually assaulted by Harvey Weinstein. Debra brings immense experience and insight to today's topic. So like I said, I will get us started with questions for our panelists, and then we will have lots of time at the end for questions from the audience. So I'm going to start with a question for you, Debra and Subodh. So as I mentioned, you both represented clients in high-profile matters that received a lot of media attention. Debra, you represented Christine Blasey Ford during the Justice Kavanaugh confirmation, survivors of Harvey Weinstein, cheerleaders and former staff from the Commanders football team who came forward about the toxic culture of sexual harassment that they experienced. Subodh, you, for example, represented the family of Tamir Rice, a 12-year-old who was killed by Cleveland police officers. So can you, in turn, share with our audience how you navigate media attention around these types of high-profile cases, and how do you use it as a tool to advocate for your client?
Me first, or?
Sure.
Sure. Well, first of all, thank you for putting this webinar together. I have long been of the view, and I've done this work a long time, that going to the media with cases that should be on the public agenda is a crucial way for us to get the issues on the public, for the public to consider these issues. And when you do that well, to get congressional oversight, to get regulatory oversight, because we live in a system that is very opposed to change. And in cases where they'll pay a little bit money, but continue to go back and do the same bad things, the only thing that gets change is when you elevate these issues, sometimes embarrass the wrongdoers, but make the cost of recidivism too high to continue the behavior. And there isn't a lot in legal training. You know, there's so much that lawyers, particularly progressive lawyers and civil rights lawyers, get criticized for trying their cases in the media. But that's not what we're doing here. We are equalizing the playing field because we are under-resourced. We never have the money that the corporations have and the wrongdoers and the bad institutions. And we're in this work to affect lasting and meaningful change. So I thank you for doing this. It's a topic that I feel really, truly passionate about, that as lawyers, we have a duty to zealously represent our clients. And part of that zealous advocacy is to put these issues front and center so they get the attention that they deserve. And when things are in the media, courts look at them differently. It encourages other people to come forward, which is crucial. for our clients, and it makes the issues undeniable that these events and these occurrences go on and they have to be addressed. So your question is, how do we navigate this issue? I think there are sort of two different aspects to this from my perspective. One is when you deliberately come up with a strategy to put these issues forward. And then I'll talk about Blasey Ford, which was somewhat different because she first made a decision not to come forward, and then she was thrust in the spotlight, largely because of media interest. So for the first, I think there is an extraordinary opportunity to put the issues on the public agenda for the purpose of validating how important the issues are, giving survivors or whistleblowers or others a voice, and really directing the conversation. So I'm going to give one example that was a successful representation. We represented Dr. Rick Bright, who was the leading COVID whistleblower during the Trump administration. This was pre-vaccine, people were dying. Trump was absolutely reckless in how he was approaching this. And we used the media essentially to do a public service announcement because this was a terrifying time. We held a national press conference, and the objective of that conference was we filed a whistleblower complaint with the Office of Special Counsel, but we knew what we needed to do was to use the media to elevate these issues. And it was a public service announcement. We had Dr. Bright explain what the administration was doing that was reckless, that was causing, deaths. Then President Trump was talking about hydroxychloroquine and people injecting bleach. There were protective gear for medical providers, nurses, nursing home people, and people who were on the line. And we used the press as a way to elevate the issues. And we used, in fact, the fact of a whistleblower complaint to provide that vehicle. So I don't know which led which, but we couldn't just get in the media and say, today we're going to talk about these things, though we might have. The press conference was so powerful, it immediately led to congressional hearings. And those congressional hearings were televised. And I genuinely believe that saved lives because Dr. Bright talked about these issues in such incredibly powerful ways. And that was a deliberate part of our strategy was we had a problem, which is people were being infected with COVID. The government's response was insufficient. So how do we raise it? And the vehicle was this whistleblower complaint. So that is one way where you use press affirmatively to get your issues out there and to drive the issues. And you use the media to elevate the issues and to report on it and to investigate it. And there were so many aspects of his complaint that the media ran on those stories for days and days and days, all different aspects of it. With Christine Blasey Ford, this was someone who made a decision, and what I'm talking about is all in the public record, including in her biography, so I feel comfortable talking about this aspect of it. She had made the decision not to come forward until Kavanaugh testified, I think it was September 3rd. And he was being lauded as this choir boy who was so great on all issues. And she just was unsettled. She did not feel good about the decision, but still, from a personal perspective, did not want to come forward until a reporter from Politico showed up in her classroom at Stanford, and it was clear that she was going to be outed. I was in Capitol Hill and Politico, not for her case, and reporters were chasing me in the Capitol to get a comment about who was this whistleblower and who was this person who was allegedly assaulted. So when that happens, you're in a different position because you're not choosing the timing. You're not choosing the medium. You're really being reactive, and it's fast moving, and your client is being thrust into a situation that perhaps she herself is not choosing. And very different factors go into how to prepare somebody for that and how to deal with that. With Blasey Ford, we knew that we wanted to introduce her to the world. And we worked with a trusted journalist who worked very carefully with her. And this was Emma Brown at the Post, and spent a good amount of time making sure that our client felt comfortable with how she was being represented in the media. And I'm sure we'll talk about this more, but that's a critical part of what lawyers do when your client is thrust into this, is to negotiate the when, the where, the how. So
Yeah,
thank
you for talking about those two different approaches when you can choose to put yourself in the media versus that choice sort of being, there not being a choice and it being thrust upon you. But Subodh,
yes.
give you a chance
So
to. here.
Yeah, I first of all, I agree with every single word that Deborah said. That's exactly been my experience. There's the reactive, where you're trying to pivot and turn things around when your client's reputation has been destroyed or is under scrutiny, and then or is at risk of that happening. Or the other side where her words exactly right. You're trying to level the playing field to create a climate and environment in which your client can get justice. And it's never about trying the case in the media in the sense of I'm going to poison a jury. I mean, I can guarantee you this is America, and I can find 12 true ignoramuses about my facts, no matter how high profile the case. I mean, it's phenomenal. We think we're the center of the universe as lawyers. My case is the most important thing in the world. It's made headlines every single day, nationally, locally. And then you'll find 12 people who are like, never heard of it or barely heard of it, don't have an opinion on it, sincerely. So it's never about that, contrary to what the big firm defense lawyers think every time we're engaged in our, magical arts. I'm going to come at this a slightly different way, though, to take two steps back and look at the framework, because you're asking about how do we navigate it, and I'm going to give you some vignettes from the Tamir Rice case and maybe a couple of others to give you a sense of that. But instead, the first question I ask at the beginning is this. I think every single one of our cases, assuming our cause is righteous, and probably everybody on this call is here because they like to represent truly righteous causes, which is why we all sacrifice incomes to do it, right? So we want to do a righteous cause. And then in those circumstances, especially when it's an individual against a powerful institution, whether it's a government institution or a big corporation, the issue for me at the beginning of the case now, after 20 years of doing plaintiff's work and before that doing defense work and having defended these types of cases, is I have to take my wrongdoer and or the decision makers allied with the wrongdoer, and I have to take them through the stages of grief. I have to take them through anger, bargaining, denial. I think it's denial, anger, bargaining, depression, and then to acceptance, right? I have to do that. And there are some folks where at the outset you think, well, if I do a pre-suit reach out to these folks, they're going to be so grateful that they can cover it up and pay some money and maybe rectify some things and then be done with it. And there are others that are going to double down and triple down for a while, and it's going to take them a while to get through the stages of grief. Sometimes I can assess that from the client. Sometimes I just do some intel, try to figure out something about the defendant. Sometimes I just know. Okay. And then there's another consideration that Debra didn't mention, which is that sometimes by publicizing, and this is a legitimate reason to do this, you gather other evidence by publicizing it, right? So I represented a whistleblower associate dean who alleged that he had reported sexual harassment by the dean against third parties, others, and then faced immediate retaliation. And I believe, based on the procedural posture, if we publicize this complaint big time, we are going to, because where there's smoke, there's fire, we're going to learn about other victims. And sure enough, we did. And then that eventually, that 7 to 9 months to take the defendant through the stages of grief, from shouting anger and condemning me in the media and all of this stuff to eventually like, hey, can we resolve this? And then we go to mediation and resolve it. So those are the strategic considerations. I'm going to give you a quick vignette from the Tamir Rice case that may be of interest to people. In that case, I just knew because, and Debra probably deals with this sometimes, is that these defendants in the state and local government situation, they get the qualified immunity defense in Section 1983 litigation. So they can drag a case out for up to 6 years if you have 2 interlocutory appeals on qualified immunity. So you're trying to figure out strategically, how do I accelerate them through the stages of grief when they've got all the time in the world as a defendant? Well, one way we did that here, we sued the city of Cleveland, or the prior counsel had sued the city of Cleveland. We amended the suit. We kept the matter out in the media. We were also pushing for criminal resolution against the officers. But this moment came where some lower level knuckleheaded bureaucrat at the city of Cleveland sent my client, Tamir Rice's mother, a $500 bill for the EMS bill that was required to transport him to the hospital. She was very upset when she got it. And she's like, what should I do? Should I pay it? I said, no, you should not pay it. You should never pay it. You're never going to pay it. If I have to fight this till the end of my career, we're going to fight this to the end of my career. You're not going to pay it, but just give me a moment. So what I did was I gave the story to the most friendly, local, sort of progressive weekly which I would ordinarily never do. You want to go to the biggest venue, but I just knew this was catnip for all media internationally. If I get the right story written by the people with the right viewpoint, it's going to explode. And sure enough, I gave them an exclusive until midnight. They published it. Then other locals started picking it up. And then more and more, it got regional, international within 3 or 4 days. I mean, I had Greta Van Susteren calling and saying, can I pay this bill? No, you should never pay this bill. I heard hundreds of calls came into City Hall. And then finally, the mayor had a press conference and apologized with the law director by his side. And then within days, they said, can we go to mediation? Can we resolve this? Right? We accelerated them through the stages of grief. Now, I thought we'd been inflicting a lot of pain up through then, but boy, did that finally do it. So what you're trying to do, and I think this is the takeaway, I'd say, and we're going to get an opportunity to talk about other strategic considerations as we go. What I'd say is, look, this is never about you. This is never about you getting your name out. This is never about just publicity for publicity's sake. Everything is strategy. Everything is anticipating, okay, it's like the war game theorists say, tit for tat. You escalate, you escalate, you escalate both sides until somebody decides to de-escalate. What you're trying to do is anticipate the next move of your defendant if you're suing a defendant. And one of the considerations has to be, is this a defendant that will get so angry that they'll never, ever resolve it and they'll go to the end of time? So those are things you talk through with your client, you figure out what's the best strategy, and you come up with the strategy and tactics to try to advance the client objective. And I'll say one last thing. This actually might be a good time to put that quote up in the chat, if you would, Lizzie. There's a U.S. Supreme Court case. It's either Gentile or Gentili. And it was, I'll come back to it later when we do the ethics part of the presentation. But the quote here that's going to get put into the chat, I think, is really important. All the white shoe firm lawyers who, have their noses up in the air that you're talking to the media and doing things, oh my God, you're such a dirty lawyer. The U.S. Supreme Court has recognized that it is an important role that we have as lawyers to protect the reputations of our client, and that includes media engagement. And this quote is directly from the majority opinion in this U.S. Supreme Court case. And we're going to discuss the holding of it a little bit later. But so don't ever be ashamed or embarrassed about the fact, and I think Debra made the point well, as an advocate, this is part of your arsenal. It just as much as the civil rules are, just as much as the substantive law is, just as much as your polished legal writing is. The idea of public engagement and how you use it strategically is as much a part of your assessment of a case and your approach to a case as anything else. And in many instances, most instances, it'll be, no, there's no public engagement at all. Not in a client's interest. Matter isn't even newsworthy. But in some cases it is. And that's when you start to pull out some of the tools in the toolkit that we're going to discuss with you today.
Thanks so much for that framework, Subodh. That was really helpful. So Robert, we just heard from Debra and Subodh about their strategic considerations when working with the media. But I want to ask you, from your perspective as a former journalist, what are journalists looking for when they choose what stories to cover? We might think as attorneys, of course, our client is press-worthy, but that might not be the same analysis that journalists are making. So can you speak a little bit to that?
Absolutely. So I would say that it is, when choosing a story, it's less about choosing the clients and the cases and more about what story the journalist, the particular reporter, is trying to tell. And in assessing that, you have to understand like the purpose of journalism. So I think Debbie mentioned a couple of times about, putting information out there on the public agenda. We would call it the public record. And the public record somewhat operates like the record in court. If you, I know a lot of our attendees are litigators, so you know that a jury only finds out information. They only know that information. They can deliberate on that information if it is introduced through the record, if it is established through the record. And that is really an accounting of the facts, right? The accurate facts placed out there for public accessibility, for public view. And that, goes back to what has already been talked about as far as the purpose. Once you do put it on the public record, that purpose is really for twofold. I think Debbie had already spoken about it. I'm just going to keep throwing it back to Debbie. I think Debbie had already spoken about trying to get congressional oversights or, some type of an action by the public. So it's to inform the public, but also to inform the public so that the public may act or do whatever it will with that information. Now, it's also, I know we're going to define journalism a little bit later on, a little more substantively. But it's also important to keep in mind that, while you are putting things on the public record and hopefully you're encouraging some type of an action by that, journalists typically keep their own personal views and opinions out of the reporting and out of the process of reporting and publication. So, we would report on these things for some type of action, but not any particular action, especially if that action leads to one political side or the other, or it leads to one entity or the other, if it's pro-corporation or pro-employee. Now, there are different publications, and it's important to know like what those publications are insofar as their political leaning or not necessarily their political leaning, but who their audience is and who they generally report to. So if you are taking a story, for example, to the Washington Post, that's going to have a different audience than if you are taking a story to the Wall Street Journal, whose audience is pretty much like business people, right? And I know we'll talk a little bit more about and flesh it out a little bit more among the different media outlets and among the different journalistic outlets as well. But knowing where to take your story or knowing like what the audience of the outlet you're going to, that helps us think about their contribution to placing this on the public record. Also, the second purpose, along with informing the public now for some type of engagement now, the second purpose of placing these things on the public record is you would want to create this story. So when, for some reason, if somebody in the future looks back until now, they'll be able to contextualize the moment and say, I guess we can look back now. We're a little bit removed from it. So we can look back now at the Me Too reporting from like 2017 on. And we can contextualize that from the reporting there. Or in 10 years, we can look back at this moment and make sense of what was going on from there. So what journalists typically look for when covering stories will have to be like having that in a foundation of what needs to be on the public record, what engages people, what interests people. Why would somebody in California would care about this story? Why would someone in Idaho would care about this story? So you will have different, you will have different demographics, different age groups of why is this particular story important? And one of the two questions that I learned in my experience, and this was like talked about in our editorial meetings whenever we would pitch a story, is why this story and why this moment, right? And of course, like that's at NPR, National Public Radio. So, our focus would be more on the voices of different perspectives sometimes than it would be on, let's say, a theory or like a legal concept or a certain event that is going on. Like this thing happened. For us, it would be, this thing happened, but also this thing happened. Let's hear from these different perspectives. So is there a perspective that is being undertold right now? Is there, because that in and of itself can be interesting if it's something that, if it's a voice on a topic or a subject matter that we haven't heard from, if it is a different point of view. Another thing would be timeliness. So what we would call news peg, why this particular moment, if sometimes in law, well, all the time in law, it takes a long time for our cases to get down the pipeline. I practice employment discrimination. So once you go from The inciting incident in my jurisdiction, Washington, D.C., and in Maryland, you'll then have 300 days to file an EEOC charge of discrimination. And from there, you may take it to court in, 180 days. So now we're at like a year and a half from the thing that happened that incited this lawsuit to the time that we actually bring the case. So you're going to have to, like, that is a lot of time that is removed, and you're going to have to explain why should the public care about this now? And you're going to have to do so concisely. So like that is a lot of why, that is a lot of what journalists will look for, what is interesting, what deserves to be on a public record, why is it timely, why the story why the story at this particular moment. And once you have those elements, the journalists will start asking questions. And there would be a lot of times where you would work on a story, you would do the reporting, you would talk to the subjects of the story, you'll go and verify the things that they told you with, a second source, maybe a third source. If there's some type of public documents, you will verify with the documents. And, there are a lot of times where the story may not lead anywhere. By lead anywhere, I mean that, if you sue somebody for, let's say, race discrimination, companies get sued for race discrimination every day. So if somebody pitches a story, if an attorney reaches out to an editor and pitches a story of, hey, I have a race discrimination lawsuit, the reporter or the editor will assign a reporter, and they'll go looking, they'll go ask questions, and it may be what we would call, I don't quite like using this term, but not to diminish the facts, but what we would call like a garden variety, quote unquote, factual pattern, where, this is something like this, the facts to this particular lawsuit is present in any other lawsuit. So there's nothing really interesting here that would engage a wide public across different geographical regions. If the publication is large enough, perhaps it's a local publication, and if it is, then maybe that's a different analysis. The journalists and editors then will only have to worry about why are the people in my city, why they would care about this particular subject matter. You don't necessarily have to do the analysis of other regions outside of that locality.
Thank you. That was really helpful. The framing of why this story and why now and who's the right audience for this, I think is really helpful to hear that perspective. I'm gonna pass back to you, Debra. And so we talked about kind of big picture strategies a couple minutes ago, but now I want to ask you, and I know that it's hard to generalize because I imagine the advice that you give your clients very much varies case by case, client by client. But if you are sitting down with a client, could you sort of distill maybe advice that you might give to a client when engaging with the media into kind of 3 big picture pieces or 3 themes? What are kind of the take home pieces of advice that you want to make sure every client understands when they're about to talk to the press?
Well, first of all, if something is truly high profile, the first consideration that I have is for the client's safety and well-being. And that is both physical safety and cyber safety. Before we come forward with something that we know is going to be shake things up and lead to people being trolled and doxxed and other very bad consequences that happen with our clients, we will work with our clients to shore up their social media and bat down all of that, because there's nothing worse than coming forward and then suffering those effects over and over. There's also a physical safety aspect of it. Christine Blasey Ford had to move 3 times before the conclusion of the hearing. And I do want to give a shout out to the National Women's Law Center in that regard, because my law firm also, we received innumerable death threats. We had to repeatedly make frequent complaints to the FBI. We had armed security at our law firm and at our homes when several of us had young kids. It was a really difficult time. And that's one thing you really have to prepare a client for, because someone may want to come forward and tell their story, but there can be significant consequences, and they have to be ready for that emotionally, physically, and in all ways. We work with our client to make sure that they have a support network. That often means a good therapist, and it almost invariably means having a good comms team in place, because there are many ways to try to hurt somebody. And in the media, by hurting their reputation and planting terrible stories and all of that, it's particularly when you deal with certain institutions and certain individuals, it becomes an all-out war. So number one, the client has to be prepared for what they're getting into. Number two, it's crucial to choose the right vehicle. That means the trusted reporter. You're making a decision whether you're working with one reporter and letting the story go forward, whether you're going to do something more globally, and what the rules of engagement are. If I have a trusted journalist that I would like to speak with my client and they agree, there's usually a negotiation, which is, I'll give you an exclusive to the story. We won't tell other journalists about the story, but in exchange, we need to have more control, not of the content. You're never going to control the content, but we can insist that reporters keep everything off the record until we agree to certain pieces of it being on the record. And it's very important to understand those rules of engagement and to navigate those well. You can't tell a reporter something and then come back to them and say, I don't want to use that. That's not how it works. You have to be very careful. Reporters are fair, but their client is the public, and it's telling the story. And if you don't engage in the right way and share things, you're never going to get a good reporter to say, okay, I'm going to give you that document back. I see why you don't want it out there. So having clarity with your client about what those rules of engagement are, and having clarity with the journalist who's writing the story about what they're going to allow you to hear about, what the comments are that are going to be attributed to your client, and also to you too, because you're the representative, and making a decision about, should the story be told for the lawyer? Should it be told for the client? If the client risks a defamation claim and they're scared of being gone after directly, then the story may be better through the lawyer. Sometimes, particularly when there's sexual abuse and sexual violence, and the client won't proceed using their name and will only proceed with a Jane Doe, it's easier post Me Too to get journalists to agree to those arrangements, but typically you need several people and somebody who's willing to go on the record before a story will run, even if it's the most well-resourced story. There are exceptions. So working with the client to understand that, because it's complicated. And so also timing. So the three buckets would be really just being prepared. And if you offer your client up to speak to a journalist, appropriate media training is crucial, because people reflexively want to answer questions that are asked of them. And some things, it's not, it's nobody's business. It's not the journalist's right to know certain private things. You can decide to go on the record about something, but there are certain areas of your life that can and should remain private. And clients need to be aware that that may not occur, but you can negotiate those rules with a journalist, but you also have to train your client that just because something is asked of them doesn't mean that they need to answer that question. So preparation in all of those areas would be the three things that I think are most crucial.
Thank you so much. And we're going to talk a little bit more about how to think about protecting your clients from re-traumatization. So that boundary setting, that support networks. But I really appreciate you naming that in thinking through some of the strategies here. And Subodh, Debra just mentioned that there are circumstances where there's good reason for the lawyer rather than the client to be the one who's speaking with the press. And we'll talk a little bit more about this later too, but for now, can you kind of distill your three pieces of advice when you're either thinking about sort of general takeaways for yourself as you're thinking about talking to the media, perhaps if you were helping to prepare a colleague, what sort of your parallel for the lawyer?
Well, let me sort of do this backwards. So I'm going to talk about first just the message, right? What's the message? And I'm doing this backwards because then I'm going to walk back and I tell you what gets me to the messaging and whether to do messaging. But let's say that I have determined that there are up to 3 things that I want to be in the story. Remember, no matter what you say, no matter what questions are asked of you, I think Debra was alluding to this too. They'll ask you something, you'll give the quote, they want to run with that. And you're like, but that's not what I wanted communicated in the story, for God's sake. So you have to say you have to be message disciplined, which means that you've got 3 points you want to make. When I'm training, younger lawyers in this, draw a triangle, write your 3 points in the corners of the triangle. And no matter what questions are asked, imagine them falling on one side or the other of the triangle and pivot to your point. Okay, that's a real practical tip. And on the rare occasions where I'll have the client do some of the media themselves, we'll do that. We'll prepare beforehand so that it's just stay on message. And if somebody persists and is trying to get the answer, then you either have to have a client who exercises good judgment or you're sitting there and you intervene. So that's sort of the message part of it. But now let me work backwards. Before you even get there, you got to say to yourself, again, assuming you're representing plaintiffs, are these defendants, and I think Robert was alluding to this too, are these defendants even genuinely newsworthy, high-profile targets? Public sector versus private sector, major public figure. Shrinking media, which we have across the country, means there are fewer voices. And so it's getting harder and harder to be heard. Second thing is publicity always angers defendants, okay? So you have to say to yourself, will publicity eventually take them further along that continuum of the stages of grief, or is it just going to make them hunker down? What kind of, and this, remember I was telling you about sometimes you put something out there and then great witnesses will come forward or great evidence will come as a result of there having been coverage. Well, similarly, your defendants and your targets and your wrongdoers will often say something incredibly stupid in response to what you've put out there. And it's an admission against interest, or it's an avenue for discovery. And we've had a lot of success with this as people come up with their knee-jerk stupid thing to say in response, and then you're able to actually make use of that in your litigation. And this is another consideration. Who are your decision makers within the adverse organization? It could be that the general counsel doesn't know what's going on. And so if you put some of this information out in the world, the general counsel is now going to turn to the CEO and go, is this true? Is there any truth to this at all? And or some other higher level decision maker is going to say that about the vice president who is sexually harassed, right? So that's a consideration. It's not that you're just communicating to a faceless corporation. You're communicating to constituencies within that thing. And then the last couple of things real quick, it might help you fact gather, as I mentioned. How will your client feel about it? What will the career impact be on them? The internet is forever now. Can you got to studiously avoid defamation claims in the way you're doing everything for your client and yourself. We may talk about that more later. So all these things are things that become a part of the consideration. And in a Title VII case, a sexual harassment or other type of case, if you can elicit specific denials, now you have targets to shoot at it in discovery to prove pretext. That can be wonderful. So I think all of those things, once you've been through that thought process, either personally or with your client, you then figure out, okay, what's my message? What do I want to put out there? And I got to stick to my message.
Thank you. And we are, in fact, Robert, did you want to jump in?
I'm sorry. I thought you had another question for me. No.
No, I was gonna follow up on the defamation point and say we're gonna talk about that now. And both Subodh and Debra, you both mentioned, the risk of defamation. We know increasingly that people accused of abuse and harassment are responding with defamation suits. Probably the most high-profile example of this was when Johnny Depp successfully sued Amber Heard for defamation after she authored the op-ed in the Washington Post. So when you're working with your clients, what do you think about when you are helping them avoid facing allegations of defamation and other retaliation? And Subodh, I see you're off mute, so I'll let you go first, and then Debra, whatever you want to.
Okay. Well, the first consideration is I tend to be pretty conservative about putting the client herself out there. right? That's something that I've done it on rare occasion where I've got a client who is just so ruthlessly smart and message disciplined and can be trained, really well, and they get it, that I'm like, this is worth it. The facts aren't going to change. There's going to be no variation in the story. We're going to sit down and my client's going to crush this. That happens occasionally. Most of the time, I'm very cautious about it. So then it comes down to, how do I help avoid a defamation claim for the client and for our firm ourselves? And that's very simple. It's just that if you look at if you want to look for model releases, you can look at chandralaw.com at our media releases on the blog, and you'll see that all the reportage about developments in the case, the content of the complaint, it's all led in with the complaint alleges that, not that this is true or that is true. I do exactly what journalists do. Now, it may be, a little spiced up more than standard journalists, but it's not all that spiced up, because it's very much the complaint alleges bullet points. And so you want to do that. You got to do that. You've got to remember, as lawyers, we're not even necessarily adopting the truth of the matter or vouching for our client. What we're doing is presenting what the allegations that are filed in court are. And as we will cover later when we talk about the ethical considerations, that's also a safe harbor under the ethics rules, that you're reporting what is in a court filing. So I think that's a primary way of doing it. It's really not worth it going down other paths. It's not worth your license. It's not worth the financial risk. And nevertheless, people may still sue you or whatever, but they're not going to get anywhere if all they're pointing to is statements that say the complaint alleges something.
Yeah, Debra, anything to add?
Sure. Well, that's certainly true if you have a filed complaint, but oftentimes we represent people who don't have claims. The statute of limitations has long run, particularly in the wake of the Me Too movement. And yet there is something extremely powerful for survivors to tell what has happened. And we have received many, many requests from the network of people who have been sexually assaulted, harassed long ago. And before the look back provisions, they had no avenue for relief.
Yeah.
What was healing, what was empowering, was telling their truth. And we saw our job as helping them do that, understanding that there was a risk of defamation claims, but also recognizing that there's strength in numbers. And when you assisted people in coming forward, it usually led to other people coming forward. And there is always a risk. But if a client with meaningful advice makes the decision that they want to come forward, and there's a reporter who is willing to tell the story and willing to do hard investigative work to see if there are other people who have been abused, we will help them. And truth is a defense to defamation. There's some very good people in the network who specialize in defending these cases, but I would not let the fear of a defamation suit get in the way of telling what happened if there is something powerful and healing about that for the person who comes to us. And finding other survivors is crucial in that endeavor. Finding other whistleblowers is crucial. And then having somebody who works with you, who does the defense side work, to advise about how best to put it forward. Without a filed complaint, I don't think it helps you a whole lot if the lawyer is making the statement and the client is not making the statement. And in some respects, suing the client looks so much worse and so much more retaliatory and thug-like. So it is something to weigh. And we've had clients with really well-documented cases of abuse who ultimately made the decision not to come forward because they feared retaliation, and they feared lawsuits, and they feared defamation and all of that. There's also another piece to it. If you really fear that, we have put clients in touch with lawyers who can help with how best to protect assets. And that's not an insignificant or unimportant activity. So all of those things.
Debra, I would just add one thing to what you just said, which is then another consideration, especially at that pre-suit phase where you're not just talking about what's in court filings, is then going through the analysis and explaining to the client if the person who's going to be complained about is a public figure or not. Because if they meet the legal definition of a public figure, then under New York Times v. Sullivan, then as a plaintiff in a defamation case, they have to prove based on the actual malice standard, which means actual knowledge of falsity or reckless disregard for the truth. And typically those cases are thrown out. So I think you're on safer ground, say, in a Brett Kavanaugh situation than you might be with a purely private actor, but a high-profile private actor then maybe a public figure. So you want to look at the law on that and do some of the legal analysis as you think about the risk factor and you advise your client about the risks.
And you know what? Sometimes the public statements of defendants or putative defendants gives life to claims for plaintiffs when they deny things that are true, when they call people liars, when they make threats.
CTG Donald Trump.
Yeah, that's exactly right.
Yeah, thank you both for that. So we're going to pivot a little and I'm going to turn to you, Robert. So we know that the media, quote unquote, can mean a lot of different things. Debra talked about earlier, having sort of a list of trusted reporters that she and her clients go to. And right, the media, as I said, it can mean a lot of things, even more so true with the proliferation of social media and online content. So from the perspective of a journalist, when an attorney is considering pitching their client story, what advice do you have about what outlets they should consider and why? A little bit earlier, you talked about audience, and audience really matters. So I have a two-part question. What advice do you have about what outlets to consider? And then when they are thinking about making their pitch, what are some of the top considerations for what makes an effective pitch?
Absolutely. All right. So, as far as outlets go, I think it would be helpful to briefly define or if we can distinguish media from the news. So media would be the umbrella term of I guess mass communication. So media is what most people think of when they're consuming things that can be, I think, labeled as content, quote unquote, or a lot of times consuming things that has an opinion in it, if there is something with an opinion or just like with an opinion or a position that may qualify as media as opposed to journalism. And journalism is really set by a standard of ethics. Now, journalistic ethics are self-governed, so it's not like what we have at the bar where there is an entity to regulate our ethical conduct as attorneys. With journalism, it is all really self-regulated there, as far as accuracy, making sure that you're pursuing the truth, making sure that you are not including your opinion or is unbiased, things of that nature. So when you look at different media outlets, that's when you can come across podcasts, online shows, social media content like Twitter Spaces is it's very specific. That's a good one that people would go to talk about whatever their content is. And so is Instagram Live. I've seen attorneys use Instagram Live at their press conference, or just if they have a large following and they just want to speak about their want to speak about their cases to their following. Instagram Live is a good one. So is YouTube as well. Different radio shows. When we think about journalism or journalistic outlets, we're thinking your traditional news outlets, like things that I know newspapers is a kind of an antiquated term right now, but your print or your digital things with a byline, your typical your ABC, Washington Post, there are your four newspaper of records in this country, which would be Washington Post, New York Times, Los Angeles Times, and the Wall Street Journal. But then you'll have, your different newspaper or different journalistic outlets depending on what city you're in, what's your particular region. That there are some outlets also that are catered to different professions, like we spoke about Wall Street Journal earlier. So that would be the distinction between a news outlet and media, and where you would end up really depends on what story you're trying to tell, which launches into the second part of the question, which is how to pitch. And I believe that Subodh had mentioned, like, what is your message, defining your message. That correlates to my, like, what is the story, where I think we're speaking about the same thing, which is, and when you think about what your story is, like, what is the actual story here that you want to present to the reporter, or if you're contacting an editor, to the editor, and the information that you will want to provide is, you will want to consider, is a thing happening to someone? If so, who is that someone? Do they have a particular vantage point or some type of nuance or interesting perspective on this? Is there a policy that's affecting a person or a group of people? Oftentimes policies can garner bigger attention because it is a much larger impact than one particular person doing something untoward to another particular person. Policies can affect a group of people, therefore can garner more interest there. Is there an authority figure abusing power? Are the facts specifically egregious in a way that would pique the public's interest? Or are the facts pretty ordinary given the context of what we do, but there's an element to the story that stands out, right? Like, these are like, content wise, these are things that you will want to flesh out and put, clearly, concisely, this story is important because of this. Like, there's an authority figure abusing power. There is a particular fact in this matter. There's a particular policy in this matter. There is a national movement in this particular story. Enhances what has already been spoken about and what has already been galvanized around in this national movement. So you will want to first state why the story is important, like, what is the actual peg here, what is the interesting point to it, and then you want to find your beat writer or find your editor. And by beat writer, I mean not all reporters cover the same topic. You have enterprise reporters who discover a thing that's happening and just write about that thing, no matter kind of what it is. You have your business reporters, you have your politics reporters, you have your legal reporters, you have your government reporters. There are different things. You have your sports reporters. If we're talking about the Washington football team, their cheerleaders, for example, or their management circling around topless photos of their cheerleaders, for example. That can go into business, that can go into sports. It's a local story. It can go just like your DC local reporter. So finding the person who covers that beat is critical, or finding the editor who will assign that story is also critical. I think we tend to kind of focus in on, this is a legal story to us because we're lawyers. But to the public, this may not be a legal story because of the nature of the parties or the subject matter. And, quite frankly, legal stories kind of bore the public. Like, if you are reporting on the law, you get a little less interest there than if you are reporting on, a corporation that allowed something to happen which broke the law, right? Like, the story went from the law being broken and what the law is, if it's like a sexual harassment case, to, okay, insert multi-state corporation has this particular policy that happens to break the law. So, you are focusing the lens on the entity, you're focusing the lens on the party. Like, people care more about, parties and people and, very tangible entities than they would with just saying that, this violated the law or this is discrimination. So if you focus it there, that will help as well. But in finding your beat reporter and finding the right person for that story, you may want to consider, if the entity, if the defendant is a national corporation, then perhaps you can pitch it to a business desk, someone who covers business, and that would be more helpful because, as Subodh was saying, you are not only speaking to the public, but also in the public are their board of governors, in the public are, their general counsel. Like there are also parties within that corporation that will have access to the story. So, if it's a business desk or if you're suing a government agency for some type of discriminatory practices or policies, maybe you want to pitch that to a reporter covering government. If it's a political official, then you probably want to pitch that to the politics desk. But you will want to find out what the particular angle of the story is and who would be best to pitch this angle to.
Thanks, Robert. That's all really helpful insight. I wanted to turn back to you, Debra. So you mentioned earlier how empowering it can be for survivors to have the chance to tell their story, which is absolutely something that we really stand by at the Times of Legal Defense Funds. But we also know that it can be re-traumatizing. And you also mentioned earlier that some of the things that you do to support clients is make sure they have a support network, certainly are looking out for their, physical safety, and also doing media training to help them feel empowered not to answer questions that are inappropriate and crossing boundaries. But I wanted to give you a chance to say if you had any other recommendations for how attorneys can help support their clients to make sure that we maximize clients feeling empowered when they have these experiences about speaking out and minimize the potential for re-traumatization.
Sure. Well, at our law firm, everyone has taken trauma-informed legal representation. That's really important. And we've done it twice. And I think it's something that we need to do every year and whenever a new person joins the office. I also want to note that this kind of work is really difficult for the lawyers who do this work. And it's like, you've got to take care of yourself in this work or you won't last, you'll burn out, and you'll make bad decisions for your clients. Boundaries are really crucial. And working with survivors, if you are the only person that your client relies on, it's not going to work. Everyone will get burnt out. And we can be trained to do trauma-informed representation, but we're not therapists. And it's important as a lawyer to be able to support and help our clients, but we also have to acknowledge that there are limitations to what we know how to do, which means that in working with our clients, it's crucially important to ensure that they have a support network. And sometimes I connect survivors with other survivors, and that becomes a really meaningful network and source of support. But I think it's crucial before sending a client into this public, highly emotional and difficult pursuit that you ensure that they have all of that really well set up for themselves. And also to tell them, and we do with really smart clients, it's going to be re-triggering, but they know that. They may not know how re-triggering, and it's very important to have a plan if it gets so bad that they start to suffer really serious mental health consequences. So you can plan for those issues, you can discuss those issues, but you can't always control those issues. And as an example, in the Blasey Ford thing, we really dealt with all issues. And lo and behold, out of nowhere, the Republicans pull up this lying ex-boyfriend. Like, who is this guy? That this is the guy that the Republicans are relying on to try to attack Dr. Ford's unimpeachable credibility. And that was really hurtful, that somebody who she had a close relationship with came forward and lied. You don't know what the triggers are going to be, but you can be certain there will be triggers. So we can discuss what might occur, but we can also discuss that something's going to occur that we don't know what's going to occur. I mean, the number of times that our clients have been betrayed by a coworker who's come forward and said, oh, they said they're going to come forward because they see this as a way to get a lot of money. I mean, horrible, horrible sense of betrayal, and that can be very re-traumatizing. clients have come forward and family members have been furious that they've done that because it's brought unwanted attention to their families. And these are the kind of issues that we have to talk about with our client, and it's part of what we've learned in the kind of work we do with trauma-informed training.
The only thing I would add to that would just be that for a client for whom it is traumatizing to tell their story, sometimes for that very same client, it's empowering. And so, especially if it's done in conjunction with therapy. So I've had clients as they're doing the therapy, and then they're finally getting opportunities during the course of the case to tell their story, whether it's telling it to law enforcement in the case of a sexual assault and harassment survivor, or in the course of a deposition or in discovery, combined with therapy, they start to find their voice, and they start to have a clearer and clearer memory, and they start to have a clearer understanding of what happened to them and how, and they begin to comprehend the grooming that occurred. And they start to use language that gets more and more and more powerful throughout the pendency of the proceeding.
Yeah, and thank you for reminding us that it's not an either or traumatizing or empowering. They can go hand in hand, and it's about making sure that we still give clients the support that they need and the choice to speak out if they want to. And Debra, thank you for naming the value of trauma and of training about how to do trauma-informed practice on our website. Danny shared the link earlier in the chat with our resources. I will use this as an opportunity to plug our webinars. We have many webinars and resources about what it looks like to support clients who are experiencing trauma. So if it's not something that your firm offers, we absolutely invite you to check out our website. And
Lizzie, I've taken it through you all, and it's just first rate. I really recommend it first and foremost.
thank you so
But I
much.
really do want to emphasize that it's very important to encourage, particularly young lawyers who are so dedicated to these issues, to get the care that they need, because this is triggering for all of us. And we just need to make sure that in this work, we support and take care of one another as well.
So we can keep doing it. Yeah,
That's exactly right.
Yep. So I'm going to change gears a little bit, Subodh, and ask you to talk about, we've alluded to this in the conversation, but talk about some of the rules regarding confidentiality that attorneys have to consider when they are sharing facts about their clients' cases publicly. So while, of course, these ethical obligations vary by state, and we have people joining us from across the country, can you speak generally about how you take these ethical obligations into consideration as you're thinking through media involvement? Danny just showed everyone who's tuning in a slide with ABA Model Rule of Professional Conduct 3.6, and I apologize that it's a little small, but everyone can also pull that up on Google. So the name of the rule is up at the top. So yes, can you speak to this, please, Subodh?
Sure. So the Gentile v. State Bar of Nevada case from the Supreme Court that's in the chat, or Gentili, in that case, what happened was there was a much more strict rule about pretrial publicity that had been imposed by most disciplinary authorities, and the Supreme Court found it to be overly restrictive, and said there are many legitimate purposes. And there's permitted speech. We as lawyers also have permitted speech. And so following that decision, then the ABA model rules, which have been adopted by most jurisdictions, I'm admitted in 3, and I think it's just about everywhere. This is the rule because it is consistent with the Supreme Court's jurisprudence and courts of appeals as well. So the general rule 3.6a says a lawyer who's participating or has participated in the investigation or litigation of a matter, and this is the key word, shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. Now, what a bunch of legal gobbledygook, right? But first of all, it's a high threshold. It's a substantial likelihood of materially prejudicing an adjudication. But what does that really mean? Oh my goodness, it means whatever a judge or a disciplinary authority decides it means. But now we're going to pivot, and this is the exciting part. Look at B. Okay, these are the safe harbors, and they're very broad. So it's notwithstanding paragraph A, notwithstanding it. So in other words, even if it has a substantial likelihood of materially prejudicing. That's what notwithstanding means as plain language. A lawyer may state the claim or offense or defense involved, and except where prohibited by law, the identity of the persons involved. So, don't betray the identity of a Jane Doe, for example. Information contained in a public record. So if you're engaged in litigation with governments and you got a bunch of records back in a public records request, you can talk about that. Court records are public records, many of them, most of them. That an investigation of a matter is in progress, the scheduling or result of any step in litigation. I represented somebody who got sanctioned by a judge because he just told a reporter when the trial was. It was ridiculous. The judge was operating from a 1963, First Amendment framework, and that was overturned by the Court of Appeals. So you can talk about the scheduling or result in any step of the litigation. Requests for assistance, we will often have that up on our blog posts. Hey, if you have information on this, if you're a witness, please get in contact with us. Warning of danger, that rarely happens in our civil practices, but sometimes it does. Okay. And then in a criminal case, and sometimes our cases overlap with criminal cases, there's plenty of information that can be given. So in other words, this is a pretty broad canvas. And if you're talking about a public record, if you're talking about a court record, and you've put things in your court filings, you can repeat those things, the content of those, by saying, as the court record says, or as our court filing says, or as our motion shows, and the rest of it is fair game and squarely fits into the safe harbor in B. And then finally, C is important to look at, which is you may make a statement that's really in response to a statement that the other side has made. So in other words, you're permitted to kind of address or diffuse the harm, to put it simply. So these are all important ethical considerations. Again, if you've not engaged in a lot of media work, or even if you have, I always commend people to go back and look at the rule and look at the safe harbors and figure out if what you're doing is okay. If the other side is going to accuse you of violating A, are you within the safe harbors? And so anyway, that kind of leaves it at that. And I think I know we're trying to catch up on some time here, so I'll leave it at that. And if there are questions at the end, if we have time for that, we can talk about this more. But I can give you many examples of where we've had to deal with this issue offensively, defensively, and got some horrible war stories and good war stories. So there we go.
I appreciate you keeping what could, I know, be a webinar in of itself to just a couple minutes, but thanks for that really comprehensive overview.
Go back and look at it.
Yes. And Subodh and Debra, you both, Debra, you mentioned this earlier. So you've both received funding from the Time's Up Legal Defense Fund for media assistance for your clients. Can you, and we are getting short on time, and I want to make sure the audience has time to answer questions, but can you talk briefly about your experience with that assistance and the impact that it had on your clients and their case?
I'll have Debra start because we're just at the beginning on our project. Go ahead.
Time's Up and the legal network through y'all were instrumental in supporting the women who came forward with the commander's case. At the end of this, we wound up having over 50 clients, and this was an incredibly successful representation. I've done sexual harassment work for 40 years. It's a long time. I can tell you it doesn't matter how meritorious the case is. Usually men do not support the case. Walking down the street in Washington, D.C., I was getting high fives from football fans saying, take this guy down. I mean, there was a unanimous sense that this guy was bad on so many levels. The network was instrumental in providing training to our clients who very courageously spoke up and gave interviews with the Washington Post that did very good investigative reporting. And they were the best advocates for their claims. As a result of their advocacy, we had congressional hearings. They received media help and prep help for those hearings. As a result of their testimony, Dan Snyder wound up perjuring himself, which then led to further investigation. The National Football League brought on Mary Jo White to investigate. She concluded that the women who testified about sexual harassment and assault had told the truth, and that led to the forced sale of the team. None of this would have happened without the support of the network and the National Women's Law Center. I do feel like an infomercial, but it's really true. And had these women not received the training that they received, they would have been much more worried about coming forward and much more scared about doing that. And having the backing of the center was instrumental. This also happened, the case got going during COVID, and people were very siloed and very isolated. And the Law Center and the network really provided a lifeline in teaching them how to be advocates for themselves. So I've had other cases as well, but that was the most recent example that was really crucial.
Thank you so much, and thank you for indulging my invitation a little bit for that infomercial.
But
And
it's true, and lawyers should take you up on it, because if a case does need press
Yeah.
attention, and many of our cases do, the deep expertise that you all have is crucial, and that's what's needed for clients to feel safe and comfortable coming forward.
And you took the words right out of my mouth. The reason I really did want to plug this is to encourage and invite folks who are in attendance, who are curious about, getting the media involved in their case, but may not know when to start if they are representing a client who's experienced workplace sex-based harassment or related retaliation, to please consider applying for media assistance. And Danny so helpfully has added the link to the chat. Did you want to add anything, Subodh?
The only thing I would say, we're just about a month or two into a project where we're getting the funding and support, and just the quality of the outside folks who are, volunteering their time, or at least, or I should say not volunteering, but on modest compensation, given how high flying they are otherwise in their representations. It's pretty astonishing. It's really good. They know what they're doing, when they develop a written strategy and start executing on it. I mean, you could just tell they're in the A leagues. So I just echo what Debra is saying. If you're in that kind of case where your client could use help and you could use that support and help in developing a strategy and executing on it and getting the word out, Time's Up really is really attracting A-list people to assist this movement.
Thank you for those kind words. Appreciate it. So before we turn to the audience, and I'd encourage you to start thinking about your questions in the audience, I'm actually going to give Robert you the last word. So as a former journalist and current lawyer, what is one thing that you wish all attorneys knew when working with the press?
That is a interesting question. I think one thing that I would want attorneys to know when pitching their stories, when working with the press, is really that the press is there. And I hate to be redundant, but the press is really there to establish the public record. So I know Subodh had spoken about the triangle, the message, like your three points that you want to emphasize and put on, make sure that is in the story. I think that is important to have a clear and concise message, because, given that journalists, reporters are going to be reading a lot of material, they're going to be talking to a lot of people. Sometimes the information may get jumbled up. Sometimes they may need to call you again and fact check and and go over the entire process in terms of clarifying different things. They're really there to make sure that the most accurate information and ideally, they are there to make sure that the most accurate information and the most unbiased information, or the information without a particular position, is on the public record. So if you can help clarify, I know a lot of us like using a lot of terms of art. If you can help like break those terms of art down, like for example, I get a lot of calls about a hostile work environment, because people hear the term hostile work environment and they think that because my manager is being an asshole, that, you know, that establishes a hostile work environment. If we can help educate people in terms of, and educate journalists in terms of this is what happened, you know, and it's okay to use terms of art. It's okay to use those legal terms because that is in the zeitgeist. That is what the public understands. But if you also can break that down and say, you know, my client experienced a hostile work environment, you know, which means, and just concisely as you can, you know, she was treated hostile. She was treated with certain hostility because of, you know, her medical condition, because of her hair, because of her race, because of her age, because of her gender, because of her sexual orientation. Making sure that you hit those elements concisely helps the public understand, excuse me, helps the journalist understand, which will in turn help the public understand, because the journalist's goal and intention is to make sure the most accurate information is out there. So if you can help just break those things down and think from the position of, if I did not have the knowledge that I have, how would I be receiving this story? How would I be reading this? And if you can answer that question, then that would help facilitate your pitch. That would help facilitate your relationship with the reporter.
Thank you for that, Robert. I feel like lawyers can never be told too many times to go easy on the legal jargon in term of arts, whether it's client counseling or working with the press. It's always such an important reminder. So I will ask folks one more time to add any questions that they may have. You can use the chat, you can use the Q&A function. As we're waiting, I want to give people a minute or two to add, but Robert, you were talking about building those trusted relationships with journalists. And Debra, you mentioned that you have, to some degree, sort of your go-to folks who you know are going to cover these stories accurately, respectfully. Maybe you can, Debra, tell us how you have gone about developing some of those relationships, identifying who those folks are, as we're waiting for any other questions from the audience.
Okay. Being a journalist is a really hard job. And to cultivate relationships with journalists is really important in terms of good reporting, having issues that you care about be covered well. But that's how you develop trusting relationships with journalists, is be a subject matter expert. It's often you're not going to wind up in the story, but if you can steer journalists to the right resources and help them think about the way to report issues, who they may speak to, you can develop a trusting relationship, and becoming a subject matter expert becomes really important. If you are interested in certain issues, track the journalists who cover those issues, look at their reporting. We get called a lot by journalists, and before I will speak to somebody, I'm going to look at what they've reported on and how they address these issues. And there's some people who have got wonderful reputations. We work very closely with the reporters who broke the Harvey Weinstein story. And those are invaluable relationships. And we know who cover the stories in the areas that we're really concerned about. There are also some journalists who we've had relationships with who we felt really burned by, and we would never work with them again. So making sure you remember who those people are, and sometimes sharing that experience. We had some really bad experiences recently with a reporter that when I reached out to other colleagues who do work in the same space, they also said, oh yeah, we've had horrible experiences with him. And I felt like, well, we really needed to share this because all of us got burned, and all in similar ways. And people need to know that because our clients really got hurt in the process. So I think being mindful of those relationships and also talking about it when it doesn't go well with other people who might be impacted is important.
Thank you for that. And I do see a question in the Q&A, so thanks, Jay. So the question is, other than the filing of a case or the end of a case, you know, that whether it's the trial or the resolution in some other form, what litigation stages have you found can trigger the interest of the press? besides the ambulance bill example, which was a really great example, Subodh. Thank you. Subodh, can I ask you to answer to start? And then also, Robert, if you have any thoughts from the perspective of the journalist.
So sometimes the filing of dispositive motion papers, including in the case of a plaintiff, the opposition to dispositive motion. If you've got video depositions in a high profile case, I'll file the video along with the transcript. Sometimes I'll sync the transcript into the video. It's costly, but I'll do it. You know, and if it's a police officer or some other mayor or high profile individual, you know, people will get to see a fun cross-examination in the deposition. So that can be a phase. Sometimes, you know, there's going to be motions for injunctive relief, important hearings. So there could be any number of newsworthy events throughout the course of a case. You don't want to overdo it. I mean, most, as Robert would probably acknowledge, I mean, most reporters are not going to view most of the things that we think are earth-shattering as newsworthy. So yeah, and obviously the result in a case is going to be if you beat summary judgment, I'll frame that on the blog as judge orders matter should go to trial. You know, you frame it in a way that's a victory for your client.
I think that, Robert. Yeah.
I'm actually glad Subodh just said that, because if you look at particular headlines, that would give you an indication of what journalists think matters as far as like the story that they're trying to tell, or the particular news peg. So one thing that whenever I see a particular headline, like this particular headline, I know exactly what stage what stage of litigation it is, and that is federal judge orders that this lawsuit can continue. I know, okay, the motion to dismiss just got defeated, right? Like that, I know exactly what that is. So when you have a ruling on a motion to dismiss, for example, and we know that at the very least in my experience, you know, most businesses that I end up suing, most corporations, you know, instead of filing their answer, they'll just file their motion to dismiss. And, you know, once that's defeated, then they'll file their answer. We'll head to discovery or we'll head to mediation, something like that. You know, if you have like, if you miss the initiating pleading, your complaint, and you have a motion to dismiss, maybe you have the hearing for the motion to dismiss that you will want to alert, you will want to alert an editor or reporter so that they can go cover the hearing. Sometimes, you know, you could pull something out of the hearing and report on that, and that could be interesting. You can get, you could glean into the temperament of the judge and, you know, any type of early signs of, you know, how the judge is seeing this case. You know, you'll learn a lot about a motion to dismiss, even if it's just on its face, even though it's just the sufficiency of the complaint. You tend to start learning about the arguments, how each party views the case, how each party views both the legal arguments and the factual arguments, how the judge views the case. So, you know, on the hearing on the motion or on the order of the motion itself, that is like that's a very good one, a very universal way to pitch your case, to make sure that it's timely at that stage of litigation. Otherwise, you know, as Subodh said, you know, discovery, if you find an interesting detail in discovery, I can think of pretty funny, pretty famous depositions. One in particular is you know, Donald Sterling deposition. But you know, there are depositions that are pulled, and that could that you know can capture the zeitgeist. That could be interesting to see how a party is responding to a question. You know, whether a party is taking the matter seriously, and also, you know, if you get something through production requests as well. You know, if there's no protective order, if there's, you know, nothing that you sign to if there's no protective order, or if there is no confidentiality agreement with, you know, the things, the documents that you receive, you know, perhaps that will be perhaps that would be an essential time as well. Otherwise, you do have your summary judgment, you do have your appeal, things of that nature. Whenever you are filing something that has a significant sway of the case, just reach out. Let them tell you no. Let the editor, let the journalist, the reporter tell you that this isn't interesting, as opposed to you assuming that is interesting. Or excuse me, as opposed to you assuming that it's not interesting, unless it's, something that's relatively mundane, or something like that. But if it's like a venue change or something like that, you may want to write that, because that is something that reporters may be interested in. Is, okay, this is now moving from the Northern District of California to the Southern District of California. And what does that mean in terms of the jury pool? What is the politics there? Things of that nature. So if it's going to spur other questions, I think that will be essential in your analysis of what stage of litigation to pitch your story.
Thanks, Robert. And we are over time, but we have gotten 2 questions. So if folks are able to stay on, I welcome you to stay on as we answer these 2 questions, but we'll encourage our panelists to try to be brief. So the first one from Rebecca in the Q&A is, some reporters are uncomfortable reporting on cases where no lawsuit has been filed, but maybe, for example, where an EEOC charge has been filed. Any tips for encouraging reporters who are concerned about reporting when there's no lawsuit? Debra, can I pass that to you?
That's hard. Sometimes we have the most meritorious cases, and if it's not in a public filing, it's very hard to get a reporter to cover it. So I don't really have a good recommendation on that, but there are so many different legal and non-legal publications that if you get turned down one place, there may be an appetite for it elsewhere.
And the next one, this is in the chat, do you recommend media outreach when the defendant is in the news for other bad reasons? For example, you have a sex harassment case and there's a news article about fraud or the CEO getting arrested for assault. So I think I'm reading that as sort of there's all of these competing stories and how to strategize around that. Subodh, do you want to jump in on that one?
Sure. I mean, I think it depends a little bit on the facts, because if you're talking about a big faceless corporation and the vice president of marketing in Chicago was involved in sexual harassment, but somebody in some other division was involved in fraud. I mean, that's a little too conspiracy theory-ish to try to push that as if it's newsworthy, but if it really is the same malign actors within a corporation, then yeah, it heightens the value of what you've got. And I'm sure Debra has probably handled a million of those situations, and I certainly have, where it really comes down to where there's smoke, there's fire. Sometimes I have a defendant who is so just astonishingly clueless in the way they live their lives and abuse and use people that, just when you think, okay, you've heard everything, everything about this person, then all of a sudden something new comes, and it may be related or totally unrelated to what you're doing. It may be just like what the person is suggesting, oh, they also happen to be a fraudster. Oh, they also happen to be a criminal. Oh, they also happen to be embezzling. Oh, they also happen to be a sexual harasser. And you're just thinking to yourself, like, can this really be my life? Like, when is the investigation in this case going to end? So
Are you talking about Donald Trump, or is this a different defendant?
That is a matter I'm currently handling as well.
I know. I was wondering if you were talking about that case, because checked all those boxes.
Yeah.
Oh, you're literally handling a case. I thought that was a joke.
No.
Yeah, no, I just filed the criminal charges in Springfield on behalf of the national.
Right on.
Oh, wow.
Trump and Vance.
That's righteous work. Thank you.
Thank you.
All right, well, I imagine people could ask even more questions, but we are over time, and if folks would indulge me for just one last minute to make some final announcements. So first, I just wanted to share 2 quick resources that relate to the topics that we talked about today. And Danny, if you don't mind just going to the next slide very quickly. So The first, and Danny's going to add a link to this, is a paper authored by Debra and Lisa Banks, another partner at Debra's firm, about the ethics of engaging with media during litigation. So thanks, Debra, for so generously sharing that. And second, we mentioned quite a bit about defamation today and the risks of when folks face defamation suits as retaliation. We have a toolkit on our website that has some great resources for survivors and that also are useful to attorneys as well. We also have a webinar about this toolkit. All of that Danny is adding to the link. And then last but not least, I want to sincerely thank our incredible panelists for the incredible insight that you shared today. Thank you so much. And thank you for this extra time and all of the time that you put into preparing such thoughtful answers. And thank you to those who attended. Thank you for your participation, your excellent questions. You will see in a minute a quick poll. I promise you it'll just take you a minute. If you could consider completing it to give some anonymous feedback about today's webinar so we can always see how we can improve in the future. And again, if you are not part of the legal network, please consider joining. You can find out more about that at the link. And please consider following us on social media. Robert, Subodh, Debra, we are just so grateful for your time today, your incredible insight and analysis, and all the incredible and amazing and important work that you do on behalf of survivors every day. So thank you so much for being here, to our panelists, to our audience, and we will have a recording of this webinar on our website soon. Thanks, everyone. Take care.
Thank you.
Thank you.
Bye-bye.